Welcome back to this second segment of this law session in public law, dealing with, of course, public order and state security. Now, in the first segment, what I tried to lay down and what I want you to understand is I wanted to flag up for you the issue relating to civil liberties. And when you look at civil liberties, it really is about your right in terms of, for example, your freedoms that you're entitled to within the state. Now, as I say, generally, you are free to do what you like as long as it is within a legal confine. So as when it comes to civil liberties, it does require you to have the freedoms which the laws say you have. So when you look at the European Convention on Human Rights, and in particular the rights that have been brought over, which of course are Article 2 to 12 and then 14, basically you are allowed those rights which have been brought over under the Human Rights Act. Within this law session, though, we're looking at how public order law does affect citizens within the state. What I want to turn to now, of course, is freedom of assembly and association, and in particular, this is where you're looking at public order law biting. English law has never really recognized any kind of specific right to assemble or process. What I mean by that is for you to go to march in a procession. Now, this, of course, is consistent with the traditional stance on civil liberties. Citizens are free to assemble, to demonstrate, process, provided that their conduct does not offend any legal rules. So again, you're free within a legal confine. Now, as with freedom of expression, with which you consider freedom of assembly and association, all of these are inextricably linked. So when you look at freedom of expression, freedom of assembly, freedom of association, they're all tied in together. And so it is necessary to consider the restrictions that are placed on the activity. So what I looked at when we looked at civil liberties, even though I talk about freedom of expression, what I want you to bear in mind is that with public order law, you're more than likely looking at somebody, for example, going on a demonstration. Now, if we're going on a demonstration, then you're looking at 1, I am seeking to express my views. 2, we're seeking to process, assemble, and of course, we're seeking to associate. So the 3 tend to tie in more or less, and so I want you to bear in mind that that link. Now, the underlying objective of the law and the basic dilemma as well for the law is to find a balance between the individual right to assemble and associate and the right of others to freedom of movement and freedom from public unrest. So, your right to march, but my right to not have your marching affect, for example, my quiet time at my home, or not to be afraid when I see you coming down the street and believe that I am going to be harmed. So rights have to be balanced. Now, there have been conflict in judicial pronouncements on freedom of assembly, and these, of course, include Lord Denning's dictum in Hubbard and Pitt. Lord Denning commented that there was an undoubted right to assemble together for the purpose of deliberating upon public grievances, and that this right includes the right to meet together, to go in procession, to demonstrate, and to protest on matters of public concern, as long as all is done peaceably and in good order, without threats of incitement to violence or obstruction to traffic, then it is not prohibited. Now, for those of you who can remember, for example, the summer in London, where you had this rampage, more or less, with people going on this riot. The problem there, arguably, is that there is nothing wrong with persons demonstrating, but it is when it crosses the line into illegality that we see the public order law coming on board. Because when you look, for example, at the Public Order Act, it provides for various types of offenses that can be committed. Now, you have offenses ranging from riot at the top, we're looking at 12 or more people assembled, right through, and it goes through to, whether 3 persons or 5 persons, or where you cause somebody to be alarmed by your conduct. So the Public Order Act provides for offenses where persons together have caused some kind of harm or fear to other people. Now, based on what Lord Denning says, he says, there's nothing wrong with people processing to say that they have a problem with something in society as long as it is done peacefully. Now, if you compare Lord Denning's statement with Lord Hewart in Duncan and Jones in 1902, he says English law does not recognize any special right to public meeting for political or other purposes. The right of assembly is nothing more than a view taken by the court of the individual liberty of the subject. So as far as he was concerned, this wasn't some sort of freestanding right. It is just something that the court recognized as part of the liberty of an individual. Now, when we look at Article 11 of the European Convention on Human Rights, it does recognize a specific right to peaceful assembly and freedom of association, subject, of course, to a number of legitimate restrictions on this right. So it's not an absolute right. And if you go back to the HRA law session, we see that this is not an absolute right. It's not that you can and you must be able, for example, to assemble and associate. It is limited by these restrictions. Now, the restrictions under English law are that the right to assemble and associate is limited as it relates to, for example, when you look at obstruction of the highway. You can process, you can have a procession and demonstrate, but not if you're going to obstruct the highway. There are statutory rules which regulate meetings and processions, including, of course, the power of the police to regulate demonstrations. And the police do have that power. There are restrictions on membership and support of what are called proscribed organizations. So it may be that, for example, when you look at certain organizations like the IRA, for example, where you see a proscribed, PROSCRIBED, a proscribed organization is one where the membership to it, for example, is restricted. Now, the law relating to the breach of the peace. So, for example, somebody's outside, they're shouting, they say they're going to come in and smack you or something. Police may very well come and arrest that person so as not for there to be a breach of the peace occurring. Obstructing the police, public order offenses, as I mentioned before. It starts off with riot, moves into a fray, violent disorder, and so on. And it just, those kind of offenses really look at numbers. So if it's, as I say, 12 or more, or if it's 4, if it's 3, and so on, will determine whether it's a riot or an affray or a violent disorder. Equally, racially aggravated offenses are also restricted as it relates to your assembly and association. Now, when you look at breach of the peace and obstruction of the police, Section 89 of the Police Act 1996, which was formerly the Police Act of 1964, does provide that any person who assaults a constable in the execution of his duty, or a person assisting a constable in the execution of his duty, will of course be guilty of an offense. Equally, any person who resists or willfully obstructs a constable in the execution of his duty, or anybody assisting such a constable, is also guilty of an offense. Now, there are some cases that you need to at least look at them, at the very least in summary format, and see how this whole notion of peaceable assembly and association does pan out. So, for example, Redmond Baton, Director of Public Prosecutions, the Austin and Commissioner of Police case in 2009 is a very important case. I would urge you to look at it. It does come back in various other areas to deal with public order and state security. So look at Austin and Commissioner of Police of the Metropolis in 2009. The case of Laporte, Laporte, and Chief Constable of Gloucestershire is also important, and I will of course flag up for you later Tabernacle and Secretary of State for Defense. Now, Article 11 protects the right to peaceful assembly. It protects the right to form and join organizations, such as, for example, trade unions, for the particular purpose of promoting a particular cause. Now, as with other articles, the right of assembly and association are qualified rights, as I said before, which may be restricted lawfully. And they may be restricted in the interest of the right of others and also for the purpose of preventing crime and disorder. Now, there is an important case to consider, the 1999 case of Steele and others and the UK, equally Gillan and Quinton and the United Kingdom. Again, these are cases that I want you to spend some time looking at, because again, they show you exactly how these concepts work in practice. Now, public order law regulates a number of different activities and situations with the overall aim of ensuring that there is a generally peaceful society where everyone can enjoy their own rights and freedoms equally. It means, therefore, that public order law will limit the right of freedom of expression and freedom of assembly. Now, the law comes from two principal sources, the common law and statute. Now, the Public Order Act of 1986 and the Criminal Justice and Public Order Act of 1994 are the two main pieces of legislation that are relevant when you look at public order law. In addition to the restrictions that we've already mentioned, you should also be aware of the various public order offenses, which I've also mentioned, like riot, violent disorder, and affray, and also the use of threat or the use of insulting words or behavior. Public order law provides for regulation of this type of behavior. And these, of course, you should need, or you should look at in depth. Now, when you are doing your reading, when you're looking at public order laws and area, you should look at police powers and see how the control of public assemblies and processions are carried out. Because you could legitimately get a question on police control and police powers when persons are assembling or indeed processing along streets. Now, the Public Order Act of 1986 does require that a notice is given to the police of any intended procession, and the act empowers the police to impose conditions on marches and where there is a serious public order or public disorder which is likely, the police may actually ban that procession. Now, similar provisions do apply to intended assemblies. So, for example, under Section 11.2 of the Public Order Act 1986, there is no requirement to give notice of processions which are commonly or customarily held in an area. Now, the types of examples would of course include the annual Remembrance Day service and of course judges' annual processions to the courts of law at the start of the new term. Now, Section 11.2 was examined in the case of R.K. and Commissioner of Police of the Metropolis in 2008. Now, the House of Lords ruled that a monthly mass cycle ride through London did not require notification to the police under Section 11.1 of the Public Order Act 1986, because they said the cycle rides had been held on the last Friday evening of the month since 1994. Although there was no advanced planning of the route, Lord Phillips said that the mass cycle ride was a procession which was commonly or customarily held in the area. Now, Lord Roger, Lady Hale, and Lord Carswell agreed that on the assumption that Section 11.1 would otherwise apply, the cycle rides did fall within the Section 11.2 exception. Now, Lord Brown said that as there were no organizers, the rides by their nature were excluded from Section 11, and so the question under Section 11.2 did not arise. Now, the point, of course, is that when you look at a case like that, it is interesting because we see the law lords arriving at the same decision but by slightly different routes. So one of them is saying, look, it comes within the exception. The other is saying, no, because it didn't meet a particular criteria, we didn't even need to go to the exceptions. I am going to take a short break there, and when we return, we will of course continue with public order law, and in particular I want us to look at the case of Tabernacle and Secretary of State for Defense in 2009, immediately after this short break.